Nairobi International Convention on the Removal of Wrecks was adoption on the 18th of May, 2007 and entry into force, the 14th of April, 2015. Provides the legal basis for states to remove, or have removed, shipwrecks that may have the potential hazards. It also provides a set of uniform, international rules aimed at ensuring the prompt and effective removal of wrecks located beyond the territorial sea. It also includes an optional clause enabling states parties to apply certain provisions to their territory, including their territorial sea. Maritime casualty as per Nairobi International Convention on the Removal means a collision of ships, stranding or other incident of navigation or other occurrence on board a ship or external to, resulting in material damage or imminent threat of material damage to a ship or its cargo. Wreck as per Nairobi International Convention on the Removal of Wrecks means wreck, following upon a maritime casualty, means a sunken or stranded ship, or any part of a sunken or stranded ship, including any object that is or has been on board such a ship, or any object that is lost at sea from a ship and that is stranded, sunken or adrift at sea, or a ship that is about, or may reasonably be expected, to sink or to strand, where effective measures to assist the ship or any property in danger are not already being taken. Compulsory insurance or financial guarantee. The registered owner of a ship of 300 GT or more, and flying the flag of a state party, has to keep an insurance or other financial cover, such as the guarantee of a bank or similar financial institution, covering the liability under wreck removal convention in an amount equivalent to the limits of liability established by the applicable national or international limitation scheme, but, in no case, exceed an amount calculated in accordance with the 1976 Convention on the Limitation of Liability for Maritime Claims as amended. Reporting of wreck. A state party shall require the master and the operator of a ship flying its flag to report to the affected state without delay when that ship has been involved in a maritime casualty resulting in a wreck. Such reports shall provide the name and the principal place of business of the registered owner and all the relevant information necessary for the affected state to determine whether the wreck poses a hazard, including the precise location of the wreck, the type, size and construction of the wreck, the nature of the damage to, and the condition of the wreck, the nature and quantity of the cargo, in particular any hazardous and noxious substances, and the amount and types of oil, including bunker oil and lubricating oil, on board. Determination of hazard. When determining whether a wreck poses a hazard, the following criteria should be taken into account by the affected state: the type, size and construction of the wreck, depth of the water in the area, tidal range and currents in the area, particularly sensitive sea areas identified, proximity of shipping routes or established traffic lanes, traffic density and frequency, type of traffic, nature and quantity of the wreck's cargo, the amount and types of oil on board the wreck and, in, vulnerability of port facilities, prevailing meteorological and hydrographical conditions, submarine topography of the area, height of the wreck above or below the surface of the water at lowest astronomical tide, acoustic and magnetic profiles of the wreck, proximity of offshore installations, pipelines, telecommunications cables and similar structures, and any other circumstances that might necessitate the removal of the wreck. Marking of wrecks. If the affected state determines that a wreck constitutes a hazard, that state shall ensure that all reasonable steps are taken to mark the wreck. In marking the wreck, all practicable steps shall be taken to ensure that the markings conform to the internationally accepted system of buoyage in use in the area where the wreck is located. The affected state shall promulgate the particulars of the marking of the wreck by use of all appropriate means, including the appropriate nautical publications. Liability of the owner. Registered owner shall be liable for the costs of locating, marking and removing the wreck unless the registered owner proves that the maritime casualty that caused the wreck resulted from an act of war, hostilities, civil war, insurrection, or a natural phenomenon of an exceptional, inevitable and irresistible character, was wholly caused by an act or omission done with intent to cause damage by a third party, or was wholly caused by the negligence or other wrongful act of any government or other authority responsible for the maintenance of lights or other navigational aids in the exercise of that function. Nothing in this convention shall affect the right of the registered owner to limit liability under any applicable national or international regime, such as the Convention on Limitation of Liability for Maritime Claims, 1976, as amended. Content of certificate. Name of the ship, distinctive number or letters and port of registry. Gross tonnage of the ship. Name and principal place of business of the registered owner. IMO ship identification number. Type and duration of security. Name and principal place of business of insurer or other person giving security and, where appropriate, place of business where the insurance or security is established, and period of validity of the certificate, which shall not be longer than the period of validity of the insurance or other security. Measures to facilitate the removal of wrecks when a wreck is determined to constitute a hazard. When the affected state determines that a wreck constitutes a hazard, then state shall immediately inform the state of the ship's registry and the registered owner, and proceed to consult the state of the ship's registry and other states affected by the wreck regarding measures to be taken in relation to the wreck. The registered owner shall remove a wreck determined to constitute a hazard. Registered owner or other interested party shall provide the competent authority of the affected state with evidence of insurance or other financial security. Registered owner may contract any salvor or other person to remove the wreck. Before removal commences, the affected state may lay down conditions for such removal only to the extent necessary to ensure that the removal proceeds in a manner which is safe and provides protection of the marine environment. What action can be taken by affected state if the registered owner does not remove the wreck within the deadline set or the registered owner cannot be contacted? Affected state may remove the wreck by the most practical and expeditious means available, consistent with considerations of safety and protection of the marine environment. In circumstances where immediate action is required and the affected state has informed the state of the ship's registry and the registered owner accordingly, it may remove the wreck by the most practical and expeditious means available, consistent with considerations of safety and protection of the marine environment. States parties shall take appropriate measures under their national law to ensure that their registered owners comply with the removal. Article 13. Time limits. Rights to recover costs shall be extinguished unless an action is brought hereunder within 3 years from the date when the hazard has been determined in accordance with this convention. However, in no case shall an action be brought after 6 years from the date of the maritime casualty that resulted in the wreck. Where the maritime casualty consists of a series of occurrences, the 6-year period shall run from the date of the first occurrence.
Thanks for watching. Please like, share, and subscribe this video among your friends and colleagues. Join our Telegram channel for latest maritime updates and exams preparations.